Thanks everyone for joining today's presentation brought to you by the SLW Institute, which was developed by the Schwegman firm to deliver educational and training content to advance your IP knowledge. My name is Brian Ness and I'm facilitating today's webinar in this series. Before I talk about this series and today's presentation, here are a few housekeeping items. If you have any questions during today's presentation, we encourage you to use either the Q&A or chat feature. Also, I'll be sending a follow-up email to each of you either this afternoon or tomorrow morning that provides a link to the recording of this webinar and a copy of today's PowerPoint presentation. This webinar series is going to be presented the Practical IP for Natural Sciences webinar series. It's presented by Schwegman's Chem and Bio legal team, and their goal is to provide practical tips to companies and universities looking for an understanding of a new era of patent law to protect IP in chemistry, pharmaceuticals, biotech, and genetic medicine. For today's presentation, we have Warren Woessner here, and he's going to take a look back at the most important IP decisions from 2017 to the present and evaluate their effect on practice in the life sciences arena. Warren, I'll let you introduce yourself and take it from here.
Thank you, Brian. Here's my Meet the Presenter page. I am a patent attorney and a founding shareholder of Schwegman, Lumberg, and Woessner. My focus is on both chemical and biotech patent law. Of course, it's hard to separate them sometimes, and they overlap. And it says expert witness on complex prosecution problems. Well, there usually are complex prosecution problems if you're being a patent law expert. And I've served as a patent law expert on what anybody would call almost industrial chemistry, all the way to new drugs and transgenic organisms. So it's been a busy year, and I was basically trying to isolate, in a way, the top 5 interesting and or influential cases from 2017 to 2018. Then I tried to limit it to 2018 because so much was going on. Every decision I'm going to talk about here, and not for any lengthy period of time, took place in 2018, except the original Federal Circuit Cleveland Clinic decision. But what is most interesting about that decision now, which went against Cleveland Clinic, is that they've petitioned for cert, and I've reviewed their petition for certiorari to the Supreme Court for writ of certiorari. Certiorari. Let's see. I had so here, these are the citations of the decisions that will let you reach them rather quickly, get to them quickly on Google or whatever, by Googling them. So I put them here so I don't have to reproduce them again during the discussion, except sort of qualitatively. Oil States was there were 2 big Supreme Court decisions, Oil States and SAS. And they both relate to inter partes review. The first big one, of course, was the challenge that inter partes review violates either Article 3 of the Constitution and or the 7th Amendment. But there was a divided court in Oil State, and the court held that the grant of a patent falls within the public rights doctrine as a matter arising between the government and others, and that it's not a private right. And that was important because public rights are contracts with the government, like a fishing license. The government says, okay, fishermen, you can go fish in certain places at certain times. And it can change those regulations and recommendations pretty much anytime it wants to, increasing the fees, changing seasons, and things like that. Private rights, though, are a lot more restrictive, and that's what Oil States wanted, the Supreme Court to rule, but didn't get it. And private rights, of course, are like ownership of land. I mean, once you have title to something like a patent, well, states argued it cannot be taken away, and in fact can only be granted by Congress. The holding was that inter partes review is an appropriate exercise of Congress to assign adjudication of public rights to the PTO, and Congress is not required to assign such adjudications to Article III courts, like the district court, for a resolution by a jury trial. Remember, Seventh Amendment, and that holding eliminates the Seventh Amendment arguments that patents should not be taken away without a trial, regular trial, but in a court. The dissent argued that the decision endorsed an unfair weakening, this is virtually their language, of patent protection against the threat of government intrusion and dispossession. They thought that the office simply was exercising too much power. However, the majority had a whole paragraph where they said that this should be considered to be an extremely narrow decision, addressing only the Article III court challenge and the Seventh Amendment arguments, but that Fifth Amendment takings clause or the due process clause in the Fifth may still apply. So we may see other attacks against the, I guess we'll say, legality of inter partes review. But of course, the majority was not, looked back and said, look, we've had things like ex parte re-examination, we've had contested inter partes re-examination, and inter partes review under the American Invents Act, AIA, is not that big a deal, both procedurally and legally. Let's see. SAS was the other Supreme Court decision, and it seemed to be a very narrow question, but it's probably more important than it might immediately seem. The primary holding was that inter partes review, if it's initiated, requires the PTO to decide the patentability of all the claims challenged by a petitioner. Well, they don't have to decide it right at the time of institution. That would be a huge amount of work. If one claim is likely to be found invalid in view of the petitioner's attack on the patentee, that's enough for the director to institute, and the director is required to institute if that is found. The Patent Office, though, is arguing that the question of what needs to be decided is different than the question of whether or not IPR should be instituted in the first place. Again, the court was deeply divided here. They rejected a PTO regulation that recognized a power of partial institution. I'm not sure if that was the PTO's term or the Supreme Court's term of inter partes review, involving review of fewer than all of the claims. And there's no Chevron deference to an agency acting beyond its statutory authority. So what the Patent Office felt in terms of making rulemaking, they felt if it was beyond statutory authority, it could be essentially ignored. But they didn't read the statute to require a binding decision on patentability of all the claims at the time of institution. At least I can't find that. I mean, it's enough for them, I think, to consider all the claims, looking for at least one that may fall due to the petitioner's attack. But they read the statute to require the final written decision, and that's after the whole procedure, to address the patentability of all of the original remaining or substitute claims, and they used the wording at the end of the litigation. They meant at the end of the IPR proceeding. And so they envisioned that, say, if 144 claims were challenged, a number might be canceled. So I put remaining claims. And of course, if amendment is permitted, there could be a substitute claim set that might be considerably shorter. And they use this kind of language to blunt the minority's opinion that this would really be a huge burden on the PTAB, the board. Now, since it's sort of interesting, more than a little interesting, the Patent Office has proposed that, and asked for comments, but they proposed that broadest reasonable interpretation standard for claim construction is applied in post-grant proceedings such as IPR, PCR, or business covered business methods. That broadest reasonable interpretation standard that they're using now be replaced by the Phillips standard used by the courts. That would bring the Patent Office into quite close alignment. The Supreme Court believed with the district court. Of course, the Phillips standard, well, by the time you get the IPR or other post-grant proceedings, you have a complete record. You have prosecution history, you have arguments made, including arguments made by the applicant during prosecution. You have the examiner's comments and rejections. You have all the prior art. And that's different than just looking at a claim term and giving it its broadest reasonable interpretation. Although you might have to look at some of the prosecution history to interpret claims and that kind of thing. But these two changes, both the final written decision, which was the spearhead of SAS, I should say, the holding of SAS, and this change in PTO construction should help streamline upcoming litigation when the claims surviving IPR return to the district court. The district court is liable to give the Patent Office more deference if the Patent Office has interpreted the claims using the same standard as the district court would use, in other words, the Phillips standard. So that's all pretty interesting. It's important to remember that if litigation is initiated and then the defendant files petitions for IPR, that the court is likely to stay the litigation. They don't have to. If for some reason they were close to a final decision, they're entitled to go ahead and make one. But most courts will stay litigation when an IPR proceeding is initiated. Probably not just when it's petitioned, but though they might stay between the petition and the grant or denial of IPR. So those two changes hopefully will clarify how IPRs are to be conducted, and will help streamline ultimate litigation decisions. Aqua Products, I wrote, sinks a PTAB decision in a case, in the Bosch case. It's an odd decision because the director was named as a party who was representing the PTAB after the original defendant and winner at the district court level chose not to participate in the appeal, or in the PTAB decision. After the original defendant winner chose not to participate in the appeal, we needed somebody. So Mattel, the director of the Patent Office, became the substitute defendant in a sense. The Federal Circuit in this case affirmed the board's ruling that the original claims were obvious, but it vacated the board's denial of Bosch's contingent motion to substitute an amended claim set. So here, the Federal Circuit is looking for a reason, many people hope, to make it easier to make amendments during IPR. And right now, the statute simply says the petitioner can, the patentee can petition to replace claims with other narrower claims, but it's that petition is not granted as a matter of right. So I'm not sure that saying that this decision will compel the PTAB to accept amendments, all narrowing amendments, is what will happen. But the Federal Circuit rejected the board's ruling that the patent owner bears the burden of proof in demonstrating patentability of a proposed substitute claims over the prior art in general, and thus entitlement to add these claims to its patent. Again, there's a suggestion that the failure of the PTAB or the challenger to meet the burden of demonstrating unpatentability there's a suggestion that entitles the patent owner to amend to enter the substitute claims, or at least will, if the board doesn't enter them, the board is going to have to provide, it's going to have to bear the burden of proof of coming forward and saying why they wouldn't permit entrance of this amendment, a narrowing amendment, or a reworded amendment if 112 is involved somehow. Let's see, or something affecting the claim clarity. Of course, I've been very involved in Section 101 patent eligibility disputes, which have been going on now since 2014, March of 2014. In May, I believe it was, I testified, in quotes, at the first hearing, public hearing, that they had relating to the standards the PTO was going to apply in view of, back then there was just the Mayo and Prometheus decisions. Of course, Alice came along quickly. So Cleveland Clinic case shows the pitfalls in trying to get claims to diagnostics, where the final step is obtaining a diagnosis or recognizing the risk of pathology developing or being present. In the case, in the Federal Circuit case, which Cleveland Clinic lost, Mariel and Ariosa decisions applied the Mayo-Alice rule, and they established. Now, this first paragraph here is from Mariel primarily, but they established, and I'm just trying to summarize the rules, the law involving diagnostics, established that the discovery of a naturally occurring correlation between a biomarker and a disease is per se, that's all there is in the claim, it's patent ineligible as an attempt to claim a natural phenomenon, unless the claims contain a further, in quotes, inventive concept and do not simply recite steps that were routine, well-known, and conventional. You can call that RWC, I guess. Now, what that inventive concept, additional inventive concept is, has been extremely difficult to identify. I don't know if I should say particularly in the life sciences, but certainly in the life sciences. And Cleveland Clinic lost its patents claiming a method to diagnose cardiovascular disease by measuring the levels of a biomarker enzyme, MPO, in the blood. And again, that seems like a simple, what I call if A, then B claim. If the biomarker is at a certain level, then the risk or the pathology is present. Taking a drink of water. The Federal Circuit held that the steps required, when this went to the Federal Circuit in 2017, in 2017, the Federal Circuit held that the steps required to carry out the test used known statistical models, and that Cleveland Clinic, this quote, does not purport to derive new statistical methods to arrive at the levels of the MPO that would indicate cardiovascular disease risk. And they noted that Cleveland Clinic in their specification did what probably most of us do, though we should never do it again in the future. They made a lot of statements like, oh, the enzyme can be determined, level can be determined by methods well known to the art. And the court said, well, this is just, proof that these are routine, well-known, conventional procedures. And they said the same thing about the statistical methods, that Cleveland Clinic doesn't, purport to derive new statistical methods to arrive at the levels of MPO. Well, if you look at the patent, it's really complicated. The statistical importance of a level of MPO to a rather complex pathological situation took a lot of work. And there are columns about the different, well, I guess I'll call it a pathological identifiers, like what's a symptom of cardiovascular disease, breathlessness after an exercise test. So Cleveland Clinic, I wrote on my blog, Patents for Life, patents number for life, that Cleveland Clinic should have purported a little harder. Again, they had columns of information about what was needed to, in the way of statistical markers of the disease to make the assay work. And so they appealed to, they've now petitioned for writ of certiorari to the Supreme Court. They've decided to do more purporting about the detection of the enzyme and the comparison steps. And they framed the question, did the Federal Circuit err in holding that a claim to a method involving natural phenomena is ineligible if it claims, and I put little corrections of grammar in here, if it claims known techniques that have been adopted for a new use and purpose not previously known in the art. In other words, Cleveland Clinic may have been using multivariate regression analysis, a known complicated statistical technique to weigh various factors. But to me, the various factors are identified and given weight by the hand of man. And I think that's what they're driving at. They also raised the question of, does the Seventh Amendment permit invalidation of patent claims under 101, say by the district court or the PTAB, just on the pleadings when there are disputed questions of fact, claim construction, and or an undeveloped evidentiary record. In other words, district courts really like 101 challenges to patents because they can grab hold of that question and resolve the litigation simply by ruling that the asserted claims are not patent eligible, and then just skip obviousness and 112 analyses entirely, anticipation 112, the other parts of the patent statute. But Cleveland Clinic is also challenging that. Now, will the Supreme Court take this up? I'm not sure. I think it's not the strongest case. But on the other hand, as I was explaining, There are some pros here for Cleveland Clinic. I mean, the specification has columns of detailed information on measurement techniques, analyses required to make the test reliable. And again, I think assigning weight to health factors like heart wall mobility or something like that, or valve function. These are clinical value judgments, and Cleveland Clinic is almost certain to make a lot out of that. And their writ is longer than the original federal. Their petition for writ of certiorari is longer than the Federal Circuit opinion that validated all their claims. The PTO had found originally that the claims were unobvious, and that the ART believed the detection of the marker in the blood samples was novel and its correlation to CVD was unreliable in the prior ART. And so they're saying, look, and I agree that the inventive concept should be found in cases where the steps, where the claim elements other than the natural phenomena are render the claim unobvious. And I think, I mean, one of the tests for that is simply take out the natural phenomena, and could you claim identifying the enzyme level, for instance, in a certain physiological sample, could you claim that technique, a technique of analysis? And if that technique would be unobvious itself, I don't know why that's not an inventive concept. Courts have said that, sort of without much explanation, that inventive concept is not determining inventive concept and making an obviousness determination about the claim do not correlate exactly, but they haven't said why they don't. Again, Cleveland Clinic on its second question does have the Berkheimer decision going for it, that recently held that whether or not a claim element represents well understood routine conventional activity, in other words, does not have an inventive concept, raises a disputed factual issue that precludes summary judgment that the claim fails 101. And of course, that was the posture that Cleveland Clinic came to the Federal Circuit with, that they should not have had their patent invalidated at the pleading stage. And the PTO, reacting to the Berkheimer memo, has released one short guidance page, sheet of guidance, then in detecting, in requiring examiners to support findings that the claims fail. This is MPEP 2106, step 2B. That's that chart that you follow to determine if patent eligibility standards are met. And in late April, they released, oddly, a guidance sheet. It was only 2 pages long, suggesting that examiners should support their finding that the claims fail step 2B of the MPEP table of the analysis of patent eligibility. And there was also, though, a paper released directly from, excuse me, Director Yanku, asking for comments about the two-sheet guidance that had come out. But now they've released revised guidance. They're trying to, and they improved upon their original guidance, and I recommend that you all take a look at it. It's not that long, but it's a series of factors that the examiner is supposed to follow. Let's see. Sorry. We'll go on to the final case at this stage. Well, it's hard not to talk more about, well, I'm running out of time, I guess, or I was going to talk more about the guidance that is available on the PTO website as a slideshow. And it's interesting. But I won't go into the differences between it and the original instructions to examiners. The Federal Circuit, I write, circumvents the Mayo-Alice rule in Vanda. And just very briefly, they decided, I mean, it was a claim directed to an improved method of treating schizophrenia with a psychotropic drug, I guess, hydrochloroperidone, comprising, first you genotype the patients to find out if they were poor metabolizers due to low level of expression of an enzyme, CYP2D6, or if they were normal metabolizers, which I guess most people are. But you don't want to dose a low metabolizer with a high dose of this drug, or it can cause a heart arrhythmia. And the claim recited the precise dosages that needed to be given. And of course, they named the specific enzyme as well. The Federal Circuit panel was divided 2-1, of course, but it held that the claims were not an attempt to claim a natural phenomena. The panel distinguished Mayo as a diagnostic method, and the Federal Circuit has never said that before. And I'm not sure it is a diagnostic method, but they said the Vanda claim was the sanctioned new way of using an existing drug that improves its safety. So by saying that the claim was not an attempt to claim a natural phenomena, you don't have to go look for an inventive concept. And so you really want to fight like a weasel. If you're in prosecution, particularly in life sciences, to stay out of the inventive concept territory. You don't want to. You're better off if you're not claiming a natural phenomena or a natural product. If you're found not to be claiming one of those, again, you don't go on and look for the inventive concept. So the patentee in this case was came out ahead. And remember, this is a method of medical treatment claim. Oddly, Mayo was too. Remember, the first step of Mayo is administering an immunosuppressive drug. The first step in this case is putting patients in 2 baskets by genotyping, and then going on and drawing conclusions from that about the doses which would be appropriate to avoid a heart arrhythmia. And again, the specificity of the compound, of course, it was one specific compound. Mayo wasn't. The dose was given specifically. There was a range given in Mayo, but remember, in Mayo, they just gave the drug to the patient. That's the first thing they did. And then in the claim, they measure the level of the metabolite to see if they've given too much drug or too little drug to a particular patient. Here, it's determined in this claim, the baskets were established before the patient got any drug. And then, again, as the court said, it was a way of using an existing drug to improve its safety, but it was a new way. Remember, new way of using an old compound is the kind of language you want to get from any fact finder. And again, like I said, the specificity throughout this claim was very important, I believe. And that's sort of it. I think I've gotten my half hour in, maybe a little bit over, but thank you for your attention.
Thanks.
I'm assuming you're attentive out there.
Yeah, thanks, Warren. Appreciate it. If anyone has any questions, we'll give it a minute here, and you can type it into either the Q&A or chat feature. Also, feel free to check out Warren's blog, www.patentsforlife.com. He discusses many of these cases in length. Also, our next presentation is going to be on opinions and Halo. I believe when you close out the menu here, you'll be prompted to sign up for that if you're interested. Again, a copy of the recording and slides will be available either later today or tomorrow morning, and I'll send an email out on that. Looks like we got a question here, Warren. Isn't a new way of using an old drug an inherent property, which is like a natural phenomenon?
Well, that's a question that goes, in my head, goes to the big sort of unanswered question of, is putting a method of treatment step, whereas a patient is diagnosed, say in steps A and B, but in step C, they're treated. I don't, the people who have been arguing that the method of treatment is also, or the results of a method of treatment, the correlation between an administered drug and, say, efficacy or side effects is a natural phenomena, I think are going to lose that battle. The Federal Circuit in dicta certainly, and the Supreme Court have said that methods of medical treatment involve action steps, not just a claim to a natural phenomena, but a practical application of that natural phenomena, which is to treat the patient. You may have to specify what drug you're going to treat them with, or class of drugs. You still have to meet written description requirement. But I guess the short answer to your question is, I think that methods of medical treatment, if you need to add a method of medical treatment step to the end of your claim after the diagnosis has been completed, that may well avoid patent eligibility problems.
All right.
Me too. Margaret wrote, I hope that this is true. I think it will be.
Excellent. Well, thank you everyone for your time. If you have any further questions, feel free to reach out to Warren directly. His email address is right there, and I'll be following up with everyone with the recording. Thanks so much for your time. Appreciate it.
Thanks for your help, Brian.